USCIS just announced one of the biggest changes to adjustment of status in years. This can affect employment based categories, family based categories, student H-1Bs, green card applicants as well. And we're going to discuss what that announcement says. So here's what USCIS actually announced. So on May 21st, 2026, USCIS released a memo that says adjustment of status is discretionary and should only be granted in extraordinary circumstances. USCIS is now signaling a more bias towards consular processing instead of applying for a green card within the United States. So, what is adjustment of status? Adjustment of status is when you are applying for a green card while physically being inside the US. This applies traditionally to different categories, for example, F1, H1B, family based categories. Usually, you can be physically in the United States and apply for your green card. So, you're adjusting your status, you're changing that status from the current status you have to a new one where you're trying to get a green card because you're physically in the United States. Consular processing, on the other hand, is when you're going to apply for a green card outside of the United States, where you apply through the US Embassy or consulate within your home country. So now USCIS is reframing the entire adjustment of status process. USCIS is emphasizing that those who came to the United States with temporary visas were intended to stay temporarily within the United States and they should return home generally to complete any immigrant visa process. So, this change is so important because now it's changing the government's posture towards green card applicants, meaning that if you're already in the United States, the officers that are reviewing your application may be stricter and apply stricter discretionary views on your application. This new this new announcement by USCIS can have potential effects on individuals who are family-based applicants. If you're filing for your spouse, your children, any family members, it can also have an impact on employment-based applicants. So if you have an employment-based visa that you're applying for, it can definitely affect you. H-1B workers, L-1 intra-company transferees, F1 students who are transitioning to employment sponsorship, um, people with pending I-485 applications as well. This can affect all of you. So we're expecting to see more RFEs, requests for evidence, which I've already heard some applications are already receiving that. Increased scrutiny, more denials based on discretion by the USCIS officer, pressure to use consular processing. This can also result in longer wait times, longer family separation times as well. This will create more of a travel risk for individuals, and this can disrupt employment for those who are being sponsored through employment categories, visa categories, and just a lot of uncertainty for applicants already in the United States. Now, I do want to clarify this memo does not automatically cancel all adjustment of status cases. So, if you filed your application, that does not mean it's canceled automatically. USCIS has not yet published a complete list defining like what extraordinary circumstances mean. So we're still waiting on more guidance from them on that. And some categories may still qualify. I'm expecting to see some categories still qualify because what we've seen with this administration is they will release a memo and then days later we will start getting more of an explanation. So I do want everyone to sit tight. Let's get more of an explanation so that we can understand. And of course, I expect to see litigation and legal challenges. Um, Cases will be filed by court in court, most likely challenging this. So, for those of you who you think this may affect you, don't panic. Just don't panic yet. Do not withdraw your applications and start trying to automatically go to consular processing. Seek legal advice. It is so important to seek legal advice so that you can understand your case. I'm an immigration lawyer. There are other immigration lawyers out there. Don't try to navigate this on your own. Review your eligibility for your case, and we need to strategize. Like, all of this is about strategy now. We need to document everything and be prepared for increased scrutiny, and this is more reason why your applications need to be submitted thoroughly, reviewed by an immigration lawyer. So if you have any questions, you want to discuss this, reach out to me, Visa Immigration Pro. Contact details are in the links provided. Thanks.